Hello, I'm Dan Marr from Hamblett Kerrigan and Dan, New Hampshire, and today I'm going to be talking about unwed couples breaking up and who gets the house. It is very easy when you're married because regardless of who owns the title to the property, it's part of the marital estate in New Hampshire. And under New Hampshire law, the divorce court, the family court, being part of the circuit court, will divide up that property based upon a variety of factors. But when you're unwed, as the circuit courts say, marriage matters, and it's not so easy to determine who gets the house, particularly if one of the people are not on the title to that property. So there might be a reason why one of you is not on the title to the property. It might be because of financing and credit issues. It might be because one of you had the property before the other got into the relationship. It could be a variety of other reasons for that. But if you're not on the title, it is tougher to deal with. If you are on the title, let me explain the partition statute. There's a statute that's out there in New Hampshire that is used regularly that allows you to go into probate court or the superior court and claim a interest in the real estate, whether your record title, and I'll talk later if you have what we call an equitable interest in the property, meaning that you're saying that I thought I had an interest when I was contributing to this property during our relationship. I'll talk about that in a moment. But in that partition statute, the court's allowed to, by legislature has stated, the courts can consider the contributions of the parties, why they bought that property, why the property was purchased, maybe to be closer to somebody's relatives that can be factored in. What's the deed say? But the deed is not conclusive, so it says undivided half interest. That's not conclusive. And then also, what's the understanding of the parties? Did they have some type of understanding? There's a variety of other issues that they deal with, but that's some of the factors that the courts consider. And the court can then turn around in a partition statute and force the sale of the property, or sometimes one party will buy out the other party. This often happens even if you're both owning the property, because if one of you moves out, you want to buy your own house. You had a relationship with this person, now you're leaving and you want to go on with your life, and you don't want this on your credit history because it's not part of your credit report showing that you have a $300,000 or $400,000 mortgage obligation. That's going to affect your ability to get a new property that you want and affect any other type of credit. So you want to deal with that issue, and you may want to force the sale. Or there might be actual equity in property. Certainly we've had an uptick in the values of properties, and you might find that you have some substantial equity that you want to get out. And that partition statute can force that issue if you're on the title. Even if you're not on the title, though, you can still make a claim for it. There's not a common law spouse situation in that, though. We have New Hampshire, a common law spouse statute, but it's only limited to when somebody's been cohabitating for 3 years continuously. They are reputed as husband and wife, and they acknowledge each other as husband and wife, and then one of them dies. The last part is very important. One of them dies. So this is dealing with claims that are being made because of somebody dying. So that's not going to be effective when one of you moves out of the house and wants to make a claim for the property and saying you're a common law spouse. You don't have a common law spouse right in New Hampshire under those circumstances. But you can make a constructive trust claim. And that constructive trust claim is one where you turn around and you say, because of my relationship, I was in a romantic relationship, it's a confidential relationship. I thought my romantic partner was going to be protecting me. And when I was contributing to this household, I thought I was contributing for a joint property that we were both owning, perhaps because I couldn't get, because of credit, I couldn't get my name on the property, but we both had an understanding that it was still going to be our property. If you can prove that in court, you might have an argument to deal with that issue. If you're, and I've tried these cases, and it's very fact specific because the courts start off with the premise that marriage matters. If you're not married, you don't have the same rights as a married couple. So because there's no common law spouse in that situation, relationship, and you then have to prove that you have an interest in this property. Saying that you've been paying your half of the mortgage during this property time, the other side's going to respond, and I have, when I'm representing the other side, I've represented both sides of these cases in different litigations. They're going to say that's rent. So if somebody's paying $1,000 to live in a 3-bedroom house, and so they're contributing towards the mortgage of the property and the taxes on the property while they're living together in that situation, the other side's going to say, well, that was rent. You would have had to live somewhere. And that's going to be pretty compelling without some more information as to what the discussion was between you. Was there an understanding between you? And in this day and age, there might be texts. So you want to save any of the text back and forth because there's a lot of communication. What would normally be in my day oral communications between myself and my spouse would be now in texts. And there's a lot of that. So that would matter substantially in the court's views if there's something in writing to deal with that. Also, was one of you actually truly thinking of this as a partnership? Were you getting into this as a partnership, a social partnership, but still thinking of it as a partnership? And you can show, look at my contribution to the property. I paid the full down payment. I paid for the second garage or the two stall garage or the porch or the deck or the like. And I was doing that because we were contributing to this property as something together that we both had an interest in. And then the court would determine if they did find you had an interest, what your percentage interest was. And then they could force a partition statute, through the partition statute, to go forward and force the other side to buy you out or sell the property and split the proceeds in accordance with that after the expenses were paid. Thank you.